The following videos were developed as a community service in partnership between the Unified Government of Wyandotte County and Housing and Credit Counseling Incorporated, otherwise known as HCCI of Topeka, Kansas. A series of 6 modules were developed by HCCI and Wyandotte County to address frequent issues that arise in the residential landlord-tenant relationship. The 6 module topics include rental applications, fair housing as it relates to screening tenants, non-renewals, terminations, and evictions, crime-free multi-housing advanced management techniques, rental licensing and inspection, and this current topic, leases. Information discussed in the landlord-tenant modules can be referenced in the Kansas Residential Landlord and Tenant Act, the KRLTA, and federal fair housing laws. To learn more about HCCI and HCCI services, including landlord and tenant information, publications and forms, or if you need to speak to a landlord and tenant counselor, contact us at 800-234-0217 or 785-234-0217. You can also visit our website at www.hcci-ks.org. Leases. The KRLTA defines a legally enforceable rental agreement, or lease, as all agreements between the tenant and landlord, either written or verbal. The terms of the agreement are subject to the laws of Kansas, as well as local, state, and federal fair housing laws. Verbal agreements. Verbal agreements are binding in Kansas, and unless some other agreement is made, the lease is month to month. And if it is agreed by both parties that the verbal agreement is longer lease term than month to month, it can be no more than 1 year. The rent due date is the first of the month. Unless there is some other agreement, such as the tenant is to mail the rent or place it in a drop box, then the landlord is to pick it up at the rental. Even though the lease is verbal, all notices must be in writing, and if eviction is needed, the process must be carried out per the terms of the KRLTA. Written leases are always advisable. A lease not only protects the tenant, but protects the landlord and the landlord's investment. A landlord can compose his own lease, but it would be a good idea to have an attorney look it over to ensure it protects the landlord and is in compliance with the law. A landlord can also have an attorney compose his lease. It is best to find an attorney familiar with Kansas landlord-tenant law. Need a lease? HCCI sells a model lease that complies with Kansas law as well. HCCI also offers other low-cost forms and publications a landlord can use to manage a property. Visit our website to purchase online at www.hcci-ks.org. What should be in the written lease? The names of tenants and occupants, the property address, the name, address, phone number of the landlord or the landlord's representative. A phone number is not required by law, but it is a good idea because if there is an emergency at the rental, the tenant needs to get in touch with the landlord immediately. A landlord should also frequently listen to voice messages and not let the voicemail get so full that the tenant cannot leave a message. The due date. You can make the rent due date any date of your choosing, but it is most often due on the first of the month. It is also important to include whether there is a grace period. For example, some landlords say rent is due on the 1st, but considered late after the 5th. In such an instance, a landlord cannot serve any late notice, meaning a 3-day notice of non-payment of rent, until the 6th of the month. Method of payment. A landlord can include how he wants to be paid. For instance, by check or money order. In the last few years, many landlords have opted for direct deposit, meaning the tenant can transfer the rent directly into the landlord's bank on or before the rent due date. A landlord can also state what type of payments she will not accept. For instance, a landlord can state she will not accept cash. Or, if the tenant has one insufficient funds check, a landlord can state he will charge a fee for the insufficient check and then no longer accept checks. Include in the lease agreement where to pay the rent. Some landlords prefer it to be placed in a drop box. Others want it mailed, while a few opt to pick it up at the rental. Or, as previously mentioned, some landlords want it paid at their bank. Include in the lease agreement whom to make the check or money out to. Late fee policies. Unless the lease includes late fees, a landlord cannot charge late fees. Also, under the law, there are no limit on late fees. But remember, if late fees are too high, the tenant who is already late on rent is probably not going to be able to pay them, and then the landlord will have to spend money to evict the tenant for non-payment of rent, resulting in more of a financial loss for the landlord. So a landlord should carefully consider a reasonable amount to charge. Lease term. How long is your lease? When does it begin and when does it end? Lease renewal information. Most leases end on the date noted in the lease. And by law, unless nothing else is noted, the lease reverts to month-to-month tenancy at the end of the lease. However, some landlords opt to have an automatic renewal clause, which could state the lease agreement automatically renews for a year if the tenant does not give proper move-out notice before the lease expires. New occupants policy. This is a policy outlining how to address a situation where the tenant wants to add a responsible party to the lease, such as a boyfriend, or add an occupant, such as a child moving in with a tenant. Guest policy. Include how long a guest will be allowed to stay with the tenant. Most landlords say no more than 1 week, and that the tenant must notify the landlord that a guest will be staying. Special provisions or agreements. This is simply any special agreement a landlord makes with a tenant. Special agreements are okay as long as they do not negate the landlord's duties. Pets policies. Any rules or policies pertaining to pets to include whether pets are permissible. Also, if you have restrictions on pet breeds or weights, and if you have rules about the pet having a city license or vaccinations. Prohibited actions on the property, such as information about illegal actions. For instance, drug use or the selling of illegal drugs are prohibited, should be spelled out clearly. Other examples include that the tenant is not allowed to have a daycare business, or the tenant may not have a trampoline or pool due to issues of liability. Security deposit information. It is important your lease states how much you will charge for a security deposit, and to get the security deposit before the tenant moves in. Some landlords state in the lease that the tenant can clean the apartment or make repairs in lieu of the security deposit. This is not a good idea, because at the end of tenancy, the landlord will most likely need the deposit to offset cleaning or actual damages to the property. Instead, a landlord could reduce or not charge the first month's rent in lieu of the tenant working on the property. By law, the security deposit cannot exceed the rent amount, no matter how many tenants occupy the property. So, for example, if the rent is $650 per month for an unfurnished apartment, then the security deposit cannot exceed $650. Also, by law, the landlord can ask for 1.5 months' rent for a furnished apartment. For a pet deposit, the landlord can ask for no more than 1/2 month's rent, and that is total, not per pet. If a tenant owns their own mobile home and wants to rent a lot, then the landlord can only charge 2 months' lot rent. Kansas law says the security deposit cannot be used to pay rent. So, for example, if a tenant says, "Use my deposit to pay my rent this month," by law, the deposit is forfeited. On the other hand, a Kansas Supreme Court ruling determined that the security deposit can only be forfeited if the landlord states this in the lease agreement in bold letters. Therefore, the statement can say the following: per Kansas law, if the tenant requests payment of rent using the security deposit, then the security deposit will be forfeited and your rent still due. Also, any damages incurred will not be deducted from the deposit, and the tenant will still owe for such damages. Non-payment of rent information. Include in the lease what happens when rent is not paid when due. Also, what constitutes a lease violation. Inform the tenant if an item is listed in the lease and the tenant is in violation of that item, or if there is a violation of the Kansas Residential Landlord and Tenant Act, that the tenant can receive a lease violation notice, possibly leading to an eviction. Pest control information. Include what things might cause pests in the rental, what to do if a tenant sees pests, and any information about pest control. Regarding pest control, it is a very good idea to include a statement in your lease that if the tenant denies pest control, it would be a violation of the lease. Additionally, bed bugs are a national and costly epidemic. It is also very important to include information in the lease and even a lease addendum regarding bed bugs. For example, if it is found that the tenant brought in the bed bugs, then the tenant will be assessed the cost of pest control. HCCI has a sample bed bug addendum you can use to create your own. Just contact us. Landlord entry. Include information about landlord entry. For instance, Kansas law says a landlord may enter to inspect the unit, make repairs, add decorations, alterations, or improvements, supply necessary or agreed services, or exhibit the unit to prospective buyers or actual purchasers, mortgagees, tenants, workmen, or other contractors, after given reasonable notice. Keep in mind, you and the tenant might have to agree what is considered reasonable due to a tenant's work schedule, etc. It is important for a landlord to know when the tenant will be away from the unit in case of an emergency. Therefore, a landlord can include in the lease that a tenant must notify of absences more than, for instance, 3 days. Lead-based paint disclosure. This is for property built before 1978. The landlord is to provide lead-based paint disclosure form when the lease is signed. The landlord is to provide the information brochure, Protect Your Family from Lead in Your Home. The landlord is to provide the information again if they ever remodel the unit. There is an exception, and that is housing for the elderly or disabled persons, unless children under 6 reside or are expected to reside there. A printable lead-based disclosure form and the brochure, Protect Your Family from Lead in Your Home, can be found on the Environmental Protection Agency's website or Kansas Department for Health and Environment's website. It is important that both the landlord and tenant sign the form. Always keep the signed copy of the lead-based paint disclosure form in the tenant's file. Many lawsuits have been filed against landlords because they did not use this form. Unconscionable lease clauses. Remember, a lease must be in compliance with the Kansas Residential Landlord and Tenant Act. A landlord can conduct an internet search or contact HCCI for a copy. If there are clauses in the lease not in compliance with the Act, such clauses could be deemed unconscionable per Kansas law. If a tenant were to take the landlord to court over a particular lease term and the judge found it unconscionable under the law, then the judge could decide not to enforce that particular clause. What should not be in the lease? We have discussed what should be included in a lease agreement. Now it is important to discuss what should not be included in a lease agreement. Exculpatory clauses. This is an agreement that relieves one party of a liability as a result or actions or lack of actions. Confession clauses, in which the tenant admits guilt in advance to any charges for damages in court. Payment of legal fees, clauses which state the tenant will pay the landlord's legal fees if they ever go to court. Waiver of rights, any clause waiving a tenant's rights. As is disclaimers, clauses which say the landlord is not responsible for making repairs which Kansas law requires the landlord to do. Eviction without notice, clauses which allow the landlord the right to evict the tenant without proper notice. Entry without notice, clauses which state the landlord may enter at any time and without notice. Surrender of personal property, clauses which allow the landlord to take the tenant's personal possessions if the tenant does not pay the rent. Waiver of jury trial, clauses waiving a tenant's right to a trial by jury. Waiver of right to appeal, clauses waiving a tenant's right to appeal a court judgment. Lease signing. It's important that all responsible parties sign the lease and initial and date at the appropriate places. At lease signing, if there is a mistake on a lease or an agreed upon change is made, it is important that all parties sign and or initial the additions or changes. A lease not signed. In plain terms, if a landlord offers a lease to the tenant, but the tenant does not sign it, yet pays the rent to the landlord without reservation, This constitutes acceptance of the lease agreement, and the lease is enforced under the law for the term of the lease, or a year, whichever is less. We've already covered what should and should not be included in a lease. It's never a good idea to hand a tenant the lease and ask them to bring it back signed. Problems can be reduced and even alleviated by sitting down with the tenant and having a true meeting of the minds. Point out key items on the lease as you go through it. You can also have the tenant initial those items to ensure you are both on the same page. Point out the following common lease terms: the rent due date and if there is a grace period. Late rent fees. It's important the tenant understands if rent is not paid by the rent due date or the grace period, that late fees will be enforced and the landlord will follow through with eviction procedures. Special agreements. For instance, a landlord allowing a tenant to make repairs in lieu of rent for 1 month, etc. What utilities they're responsible to pay. Policies for pets or pet fees. Remember, a service or assistive animal is not a pet, and a landlord cannot charge a pet deposit, pet fees, or pet rent. Point out how much written notice the tenant needs to give to terminate or not renew the lease, and that it needs to be in writing. Normally, a lease states the tenant must give 30 days notice to vacate before the lease ends. If the tenant does not terminate the lease with proper notice, what happens? It's important to define clearly what is expected. If a landlord has no expectations and just lets the lease run out, then he has no idea whether the tenant will be moving out the last day of the lease. If this happens, there is no time to plan to put new tenants in place. Improper planning can lead to loss of income. Therefore, inform the tenant in writing of how much notice they must provide to terminate the lease. Most landlords require 30 days written notice given on or before a rent-paying date, and some landlords even require 60 days or longer notice. Some landlords even state the lease automatically renews for another year if no notice is given. What happens if there is a fire or flood? Who pays for the tenant's lost items? A landlord may or may not choose to add to the lease that the tenant must have renter's insurance to cover belongings owned by the tenant. However, he may want to point out that a landlord is not typically responsible to pay for a tenant's lost items due to fire or flood, or some other casualty, so renter's insurance is a very good and inexpensive idea. Point out co-tenant information. If there is a co-tenant and one of the tenants vacates early, explain that even though both tenants are liable for all provisions of the lease agreement, whether they stay or go, if payment is not received because the lone tenant cannot pay on his own, the landlord can or will still move to evict all parties on the lease agreement. What will happen if there are lease violations? Explain if there are lease violations, the tenant will receive a 1430-day notice of tenant noncompliance, and the landlord will move to lease termination if actions are not corrected. Also point out if lease violations occur, this could affect the reference a landlord might give the tenant in the future. What will happen if the tenant does not pay rent? Point out that if rent is not paid, late fees will incur, followed by legal eviction if payment is not promptly caught up. It is also a good idea to explain to the tenant how an eviction will affect their credit, as well as their ability to rent in the future. Changing the terms of the lease agreement. After lease signing and any time during the lease agreement, if the landlord decides to change a term or a rule in the lease, per Kansas law, he cannot do so until the lease expires, unless the tenant agrees in writing. Therefore, if the landlord wants to change or add a term to the lease, or perhaps even raise the rent, the landlord should give 30 days notice in writing before the lease term expires and explain the lease change. This gives the tenant time to decide whether they want to sign the lease with a new term or look for another property. Giving even more notice than 30 days is not required, but it is a good idea. Expectations and follow-through. Landlords who don't emphasize expectations and do not follow through with consequences of non-compliance with lease terms end up feeling defeated and have a negative feeling towards their job and have a negative and sometimes unfair view of all tenants. Landlords who are content and oftentimes succeed have a thorough lease and explain their expectations during the lease signing as well as follow through when issues need to be addressed, even if those issues lead to legal eviction. A landlord can be a nice person and a good landlord, but it's a business. If a landlord wants to be successful, she should say what she means and mean what she says. Need more information? Free answers are available at HCCI. You can contact us at 800-234-0217 or 785-234-0217. You can also visit our website at www.hcci-ks.org.